Wanted to show you a new video that the Regulatory Transparency Project just released on the SEC disclosure divide. Has some wonderful experts on the video, as well as the new Secretary of the U.S. Department of Energy, Chris Wright. We won't show the whole video, but it is available now on our website. We wanted to show you a quick trailer now, and then in a couple minutes we will start the panel. So if I could just have your attention for the trailer, and then you can resume your lunch conversations. Let's work on the audio. Hold on one second. They'll play it when they got the sound fixed.
The SEC rules want you to disclose what our damages are from extreme weather and what our plans are for the future of dealing with extreme weather. But what does the SEC know about climate change?
Most greenhouse gas emissions come from the private sector. For years, there have been voluntary climate disclosures that many companies have made. The SEC rule would make these disclosures uniform and mandatory.
The emissions that we're benefiting from today will cause 100 or more generations to suffer harms, and yet we don't have to account for those today. In many cases, the federal government is trailing behind where the American public is in terms of environmental protection.
SEC was created to regulate financial markets, to all businesses and how engaging in environmental regulation. If you go around Congress, you're setting a dangerous precedent. You're eroding the foundations of our democratic system.
something to be aware of.
Dangerous, yes.
Yes, no under the breath comments that everyone will hear.
Right.
Okay, good afternoon again. As I mentioned, my name's Nate Kazmarek. I help run the practice groups at the Federalist Society. Welcome to this RTP luncheon. It's great to be with so many friends here at the Mayflower, and thank you to all of you joining us via the live stream today. Our theme today is state climate superfund laws and related legal issues. We plan to discuss the recently enacted Vermont Climate Superfund Act and the New York Climate Change Superfund Act, and much more. We are pleased to have a great moderator and an expert panel gathered for this discussion. I would note on the front end that one of our panelists could not join us in person, but is joining us via the live stream. We're very grateful to Robin for her willingness to join us, even though I know she's feeling under the weather. But in favor of getting right to the conversation, I will briefly introduce our moderator, Jared Kelson. Jared is a partner at Boyd & Gray. He worked previously as an attorney advisor in the Office of Legal Counsel at the U.S. Department of Justice. He clerked for Judge Thomas Griffith of the U.S. Court of Appeals for the District of Columbia Circuit and Judge J. Harvey Wilkinson III of the U.S. Court of Appeals for the Fourth Circuit. His law degree is from the University of Virginia, and his undergrad is from BYU. Full bios for Jared and our entire panel are available for your review on RTP's website, regproject.org. That's regproject.org. Once the panel has concluded their own discussion, we will have time for questions from the audience. So please think about your questions as you listen to this conversation. With that, please join me in welcoming Jared and our panel.
Thank you and good afternoon. Welcome to today's Federal Society panel on state climate superfund laws. In May 2024, Vermont passed S-259, the Climate Superfund Act, which became law without the signature of Governor Phil Scott. Its stated purpose is to secure compensatory payments from responsible parties based on a standard of strict liability to provide a source of revenue for climate change adaptation projects in the state. The Act applies to any entity that engaged in the trade or business of extracting fossil fuel or refining crude oil, and which Vermont determines is responsible for more than 1 billion metric tons of greenhouse gas emissions from 1995 through 2024. Such parties must pay their proportional share of the costs of climate change adaptation projects and all qualifying expenditures supported by the newly created Superfund. In June 2024, the New York legislature followed Vermont's lead by passing S-2129, the Climate Change Superfund Act. Governor Hochul signed the bill into law last December. That act similarly assigns liability to any entity engaging in the extraction of fossil fuels or the refining of petroleum products, and which New York determines is responsible for 1 billion metric tons of greenhouse gas emissions from 2000 through 2018. Those parties must pay their proportional share of $3 billion in annual assessments for the next 25 years, totaling $75 billion in collections. Both bills apply to the extent that parties are subject to personal jurisdiction within those states. Similar legislation has been introduced in the U.S. Congress and at least 11 additional states, including California, Connecticut, Hawaii, Maryland, Massachusetts, New Hampshire, New Jersey, Oregon, Rhode Island, Tennessee, and Virginia. In addition, some of these bills accompany related proposals to create private rights of action against fossil fuel companies for individuals asserting damages of at least $10,000 as a result of extreme weather that's attributable to climate change. Again, but this time based on emissions dating back to 1965. The proposals also include fee-shifting provisions that strongly favor those individuals bringing lawsuits and that are unavailable to any entity that seeks injunctive or declaratory relief against enforcement of the law. Both the Vermont and the New York laws have already been challenged in federal court. The plaintiffs there argue that the Superfund laws are preempted by federal law, that they violate the Commerce Clause and horizontal federalism, and that they are unconstitutionally retroactive under the Takings Clause and Due Process Clause. The lawsuits also raise questions about the burgeoning field of climate attribution science, which claims the ability to determine responsibility for harms caused by climate change. Rejecting these arguments, proponents of these laws say they are modeled after the Comprehensive Environmental Response Compensation and Liability Act, which is quite a mouthful and commonly referred to as CERCLA, which creates superfunds to remediate environmental harms by imposing liability on responsible parties. Multiple circuit courts have upheld CERCLA against constitutional challenges, although the U.S. Supreme Court has never considered those issues. Today, we are fortunate to have a very knowledgeable panel to discuss these recent laws. First, Robin Craig is the Robert A. Schroeder Professor of Law at the University of Kansas School of Law. She's a prolific scholar, author, and editor, including on subjects of environmental law, climate change, and toxic torts. She is also an elected member of the American Law Institute and the American College of Environmental Lawyers, and she has been appointed to the International Union for the Conservation of Nature's World Commission on Environmental Law. She's also served on 6 National Academy of Sciences committees. Second, Donald Cochin is the Professor of Law and Executive Director of Law and Economics, Director of the Law and Economics Center at George Mason University's Antonin Scalia School of Law. His scholarship focuses on areas of constitutional law, natural resources and environmental law, tort law, and law and economics. He, too, is an elected member of the American Law Institute. And third, Jim Wedeking is counsel at Sidley Austin, LLP. He is an experienced environmental litigator representing entities in the defense of criminal and civil enforcement actions, toxic tort claims, and complex civil litigation. His clients have included large companies in the oil and gas, electric power, chemical manufacturing, mining, and automotive industries. The panel today will proceed as follows. Each participant will take 5 minutes for their general remarks on climate superfund laws, at which point we will proceed through the following issues. First, are climate superfund laws preempted by the Clean Air Act and/or federal common law? Second, can climate superfund laws premise liability on emissions that originate outside the respective borders of their states, commonly referred to as out-of-state emissions? Third, are climate superfund laws unconstitutionally retroactive, imposing liability on emissions that occurred many decades ago? Fourth, are climate superfunds analogous to CERCLA liability and associated superfunds? And fifth, is there a potential for double liability from ongoing greenhouse gas tort litigation? And does that raise legal concerns? Following the discussion, we have reserved 15 minutes for questions from anyone here today. Professor Craig?
Thank you, Jared, and thanks to the Federalist Society for inviting me to be here. As you'll probably hear in my voice at some point, I did pick up a nasty bug that I didn't think any of you wanted me to be sharing. So I appreciate the opportunity to participate remotely. The climate change superfund laws are the latest attempt to make the harms of climate change a state law legal issue. Climate change comes with lots of costs, including the cost to adapt. And this is the latest in a long and evolving line of attempts to use state law to address climate change itself and to address the costs it's imposing. So for context, those efforts have included and are still including state common law tort lawsuits. These are still generally grounded in nuisance, sometimes negligence, occasionally common law fraud. We have a series of lawsuits in states using state consumer protection laws to try and get at the various aspects of climate change. We have a few lawsuits that are getting into products liability, which is what I think is most relevant here. And the latest wave has involved state environmental rights provisions, which tend to appear in state constitutions and have recently been successful so far, at least in Hawaii and Montana. Plaintiffs are also seeking a wide range of remedies in these lawsuits. They've ranged from injunctions against the state itself to damages for harms already experienced, to payments to have to relocate because of coastal inundation, for example. So again, we've had a lot of efforts to try and make climate change a state law relevant issues. The climate superfund laws, starting with Vermont's, style themselves as mechanisms to get money for climate change adaptation project funds from primarily oil and gas companies. They as Jared mentioned, they focus on how much carbon these covered entities have emitted over a period of time in the past, and they seek to charge them a proportional pro rata share of whatever the total fund is going to end up being. Vermont's going to leave that to be calculated. New York has got the cap of 75 billion. Maryland is at 9 billion. We're going for a pro rata, basically market share liability. And so what I'm going to be suggesting throughout my comments here today is that these laws encapsulate some pretty interesting facets, both of the original Superfund taxes and of cutting edge products liability law, including market share liability. And I think if you view these acts from a toxic torts perspective rather than from a CERCLA or a regulatory perspective, you might come up with some different answers to some of the questions we're going to be addressing. So thank you very much.
Thank you, Professor Craig. Professor Cochin?
Yes, thank you to the Federalist Society and to the Regulatory Transparency Project for having me here today. As Jared noted, we're going to go through a series of questions, so I'll keep my remarks just sort of to a framing aspect here. One thing I think we need to think about in terms of the climate superfund legislation is how does this fit from a comparative perspective in what we expect our institutions of government to actually do? What is the traditional role of courts and what is the traditional role of a legislature? A traditional role of a court is to, in fact, provide due process to litigants to determine whether wrongs have been committed and to provide compensation for those wrongs to make someone whole. Those ideas of due process include knowability of what was wrong at the time you did it, and therefore an ability to forecast what your liabilities might be in the future. In other words, the rule of law requires a prospective nature of law, and at least in terms of litigation, the only thing that it's doing retrospectively is looking back at what were previously considered wrongs, not creating new wrongs going forward. This idea then of seeking out redress for wrongs in our judicial system has brings with it a whole package of rights, protections, and processes that get lost when you can have an ipsy-dixit determination of liability instead in a legislature. And so from a comparative perspective, I think we need to be asking ourselves, is it appropriate for a legislature to accomplish what a court could not in terms of imposing direct liability on individuals for past lawful behavior that could not, in fact, be litigated in court, and perhaps is being done because of the frustration of seeking redress in the court system precisely because the standards cannot be met for due process to bring these claims in court. So in light of that sort of perspective, do we allow legislatures to, in fact, impose this kind of retroactive liability? And I know that's one of the questions that we'll be coming to. And important, I think, here is a couple of motivations and incentives that need to be considered as well. The motivation, in part, is indeed going to be the failure to accomplish the ends that have been sought to achieve by many of these states and municipalities that have been bringing lawsuits across time. The other thing is that the incentives here are indeed for wealth redistribution to find individuals who can be held responsible and whose pockets can be picked for these kind of remedial measures that simply the states do not have the funds to do or don't want to go to their citizens to ask for those funds. So again, the incentive structure is designed to create a separate and independent source of revenue for public activities that truly should be accomplished through the public fisc and not through the identification of a few private funders along the way. So with that backdrop, I think then the second thing to understand, and Professor Craig has already helped to introduce a little bit of this, is where does this fit in the timeline in terms of a comparative perspective of seeking climate change kind of redress. And if we look at the timeline, or what we might call the climate liability ecosystem, we see that in the the early part of the 2000s, we had several suits that were brought under federal law trying to claim that there was a public nuisance on the part of energy production and energy companies that was committed as a result of doing lawful activity. These failed most clearly in AEP versus Connecticut in the Supreme Court, when they determined that federal common law does not contemplate public nuisance claims against this, and indeed that it has been any kind of common law that might have existed has been displaced by the Clean Air Act, and the Clean Air Act therefore was the sole place for the remedy for anyone seeking redress in all of this. Now, there's been a lot of debate in the past 15 years now since AEP versus Connecticut as to what exactly that means in terms of state law issues and state law litigation, and we've seen a bunch of that happen. But pretty much the idea of bringing federal common law claims was foreclosed based on some of the same arguments we'll talk about preemption in just a little bit as to whether or not these state legislative acts probably should not be allowed to go forward, just like federal common law claims should not be allowed to go forward because of the existence of the Clean Air Act and the occupying of the field by Congress. But when that failed, then those who were interested in imposing greater liabilities on individuals retroactively for past energy production sought out alternative approaches. And so they started bringing instead state law public nuisance and later consumer fraud and other claims in courts. Those in federal court started seeing defeats in the late 2010s in the Northern District of California, and then in Chevron versus New York and in the Southern District of New York. And we see these cases being dismissed that say, no, in fact, you cannot bring state law claims for public nuisance in federal court, and that, in fact, again, AEP versus Connecticut meant what it said, and there's basically no room for that kind of litigation here. So never not to be industrious and innovative, the plaintiffs' attorneys and the municipalities who were seeking out ways to fill their coffers thought of a new strategy, and that was to bring state law claims in state court, and very carefully crafting these so that the four corners of the complaint did not include any federal claims, and therefore, although many of the defendants tried to remove the cases, eventually they were unsuccessful based on the court determining that you could not remove when there was no federal issue raised in the complaint, and we know that federal defenses generally do not provide status for removal. And so there was a bit of a victory seen there a few years ago when those cases were not seen in federal court. And so we started seeing finally some of these cases coming to the merits. And as they came to the merits, then you started seeing defeats. And so in Delaware and most recently in New Jersey, recently in Baltimore, we've seen court after court determine that there is not really a colorable claim, and the motions to dismiss have been granted in many of these cases. Now, we have seen some other successes in Hawaii and Montana based on their constitutional claims, so there's a bit of a mixed bag, but there's certainly not a great prognosis, I don't think, for the merits claims in courts. So we have to seek something else, and what I think you're seeing here is a bit of a whack-a-mole, an attempt to find liability somewhere and to find some institution who can impose it, and the climate superfund laws really are just the latest iteration of that overall climate liability ecosystem. And seen in that light, we should also be skeptical of legislation which essentially attempts to usurp the role of the judiciary or is there to try to displace the safeguards and guardrails that the judiciary would otherwise provide for defendants. So I think we'll talk more about the specific issues in just a moment.
Thank you. Mr. Wedeking.
All right. Well, thanks for having me, and thanks to everybody for coming out. I am the traditional CERCLA environmental lawyer. My job is to give you a very brief 60-second overview of what CERCLA is and how these laws compare to it. So the Comprehensive Environmental Response Compensation and Liability Act was enacted in 1980 after a run of really nasty and abandoned industrial sites, one of the most famous being Love Canal, where they built a housing neighborhood on top of an abandoned industrial site. People got really sick. President Carter sent in the precursor to FEMA to helped them out, houses got demolished, people got relocated. And that really became a symbol of sort of a legacy of old industrial activity, whether it was, mining tailings that were bigger than buildings, or old abandoned warehouses full of barrels, or, that lovely time when the mafia got in the waste disposal business and just started dumping things in rivers and woods. So the idea at the time was EPA had to act now to do something about this. So Congress enacted CERCLA and created what was called the Superfund, which was a giant pot of money funded by taxes on chemical production that allowed EPA to go out and start removing barrels, moving dirt, relocating people, doing actual work at actual sites to get rid of contaminants until they were cleaned up enough to use again. So EPA had two options. It could either do the work itself, use the money from the Superfund, and seek reimbursement from the companies that had some tie to the site, or they could identify the companies themselves and say, you pay to do the work yourself. You hire the contractor and work at our direction. And this would go on until the site reached a set of predetermined cleanup levels. EPA would, after 30 years or so, say, you know what, it looks fine to us, and you can build new industrial sites here. CERCLA is interesting because it really pushed some of the limits of due process, joint, strict, and several liability. You could pick one financially viable company, make them do all the work, and say, look, you pay the bill and split it with all your buddies later. You go after them to figure out who's actually responsible for what percent. EPA doesn't have to get involved. EPA needs to stay focused on the cleanup. The parties that do this work are called potentially responsible parties, or PRPs, because this is a scheme where liability is determined after cleanup is finished. So theoretically, you could spend tens of millions of dollars on a cleanup and then contest your liability and find out that you aren't actually liable at all. So there are a lot of really weird tweaks about CERCLA that spawned a lot of challenges about retroactive liability for perfectly legal behavior, and bills of attainder and ex post facto laws and things like that. So how do these laws stack up to CERCLA? Well, the thing they have in common is that you have a government entity looking at a private entity and saying, give me money. That is where the similarities end. Otherwise, these schemes really don't have anything to do with Superfund at all. So some of the major differences are there's no site. CERCLA involves a geographically delineated site and says the contamination, which is specified as these chemicals, runs from here to here. It's in the water, it's in the groundwater, it's in the soil. We're going to have a remediation plan. We're going to actually move dirt. We're actually going to clean water. We're going to get the contamination out of there, and then at some point, this site will be cleaned up. Here, there's no site. There are no cleanup goals. No remediation ever takes place. No pollutants are removed from anything. And nothing's actually improved. It's just a scheme to collect money into a slush fund for everything from EV subsidies to bike lanes to routine road construction. And the fact is, there's nothing in these bills that prohibit the legislature from reallocating the money to something else. I mean, New York could use some of the $75 billion to build a new football stadium. Not like either of its football teams deserve a new stadium, but there's no limit. You don't have this problem with EPA because you either reimburse EPA for costs it actually spent cleaning things up, or you're the PRP and you run the contractors yourself. There's no slush fund involved in a real CERCLA job. And the other part is because there's really nothing to reimburse, the damage claims in these bills are completely arbitrary. If anybody's seen a methodology for getting $9 billion or $75 billion, I haven't seen it. And lastly, because nothing's remediated, nothing stops the state from going back over and over again to these same companies and say, give us more, or expanding the types of companies that they want to go after. And the fact is the absence of incurred costs is really important when you get to some of these constitutional challenges, because one of the big ways that EPA defeated the challenges to CERCLA in the 80s is that courts said, this is a cost reimbursement scheme. This is not a fine. This is not punishment. These are not civil penalties. This is only okay because there's a legislative purpose in reimbursing the EPA for work it's already done. If there's no work, it's going to be a lot tougher to rely on those cases and say like, oh, well, this scheme's fine. It's already been vetted. Another big problem is that CERCLA includes everyone who contributed to a site's contamination. That includes small towns, that includes the Department of Defense, that includes every big company you can think of. These bills turn CERCLA completely upside down. So under CERCLA, there's an exemption for what's called a useful product. So to take an example from like Burlington Northern, a Supreme Court case, if you manufacture pesticides, you're not going to be liable because one of your customers downstream, sprays them somewhere and it gets in the water, then it has to be cleaned up. You sell a useful product. Instead, it's the polluter that pays under CERCLA. In fact, that's the entire mantra behind CERCLA, is the polluter pays. Here, these bills identify a very small number of companies that make a useful product and declare them liable for the emissions of other people. So here, the actual polluters who emit GHGs are the ones shielded from liability. Everyone in this room is responsible for emitting GHGs. So will be, whatever judge who decides cases that challenge this. And governments are among the greatest contributors of GHG emissions. I mean, if you look at the state of New York and take all of its municipalities together, state-owned buildings, police cars, ambulances, snow plows, marine vessels, airports, hazardous waste combustors, landfills. New York's total GHG emissions as a group of government entities is going to dwarf probably the 10 biggest fossil fuel companies. But they're shielded from liability. They're the polluter. In fact, what's kind of amusing is when you look at New York's list of like the projects they're going to take this money to do, this is a very long list. These are just a couple of things from it. And it says all iron, steel, aluminum, glass, copper, manufactured products, vehicles, trucks, construction equipment, earth-moving equipment, cranes, drilling equipment, rebar, brick, aggregate, concrete, block, cement, timber, lumber, tile, and drywall used or supplied must be made in the USA. That gives you an idea of how many fossil fuels emissions are going to be burned doing the supposed remedial and adaptive projects that this stuff is going to fund. I mean, this is going to cause more GHG emissions. And the fact is, it's the biggest polluters that are the ones that are shielded from liability both before and after this scheme kicks in. So yeah, that's probably the biggest thing, is that this is something that goes after production and not pollution. So among many others that we could talk about later if anybody's interested.
Thank you. All right, well, let's move on to our first issue for discussion. Are climate superfund laws preempted by the Clean Air Act and or federal common law? Professor Craig, do you want to kick us off?
Sure. I would say no, they're not. First of all, starting with the fact that there is a presumption against preemption of state law. We're looking for a conflict with federal law. First of all, I don't think the climate superfund laws actually interfere with the operations of the Clean Air Act. They don't regulate emissions per se. They're imposing liability for emissions that have already occurred. And we have a savings clause in the Clean Air Act to begin with that says that any state or political subdivision thereof can adopt or enforce any standard or limitation respecting emissions of air pollutants or any requirement respecting control or abatement of air pollution, so long as it's at least as strict as federal law. So, like I said, we have the presumption against the preemption. We have a savings clause in the Clean Air Act itself. We have the fact that this law does not directly interfere with the operations of the Clean Air Act. And that's important because we have a analogy of a preemption decision out of the Clean Water Act situation involving interstate nuisance claims, which this is not. But in International Paper Company versus Ouellette in 1987, the U.S. Supreme Court said, look, what we're really worried about with state law claims are state law claims that interfere with the operation of the Clean Water Act and its kind of global regulation of water quality. And so it said Vermont couldn't bring a nuisance claim based on Vermont law because that imposition of Vermont standards, which might be different from New York's, were going to interfere with the permitting process in New York. It did say, however, that a state law nuisance claim based on New York law was perfectly acceptable because that did not interfere with the operations of the act. And I think the same is true here. These climate change Superfund laws in imposing liability for past products that eventually lead to the emissions of greenhouse gases are not interfering with the operation of the Clean Air Act in its day-to-day operation, regulating those sources or any other sources. And so I would say no, it's not preempted.
I think that on the preemption question, we have to look at a few different factors here. One is the imposition of liability, essentially, is changing and directly controlling the activities of these producers, not just inside New York or not just inside Vermont, but also casting judgment and changing the character of their activities throughout the country. Indeed, would affect even international operations in many ways in order to avoid the liability that might be imposed. These are the kinds of things that Congress has understood to be transboundary effects that require a national scheme, and the Clean Air Act has indeed provided that national scheme. It has involved balancing of competing interests that will be disrupted, the balancing in terms of authorizing particular activities and authorizing them as lawful activities without an additional tax, all come as part of the Clean Air Act permits that these individuals, that these companies are receiving in order to operate. The Clean Air Act is meant to be a comprehensive regime which simply cannot operate effectively if indeed there is a state-by-state regime that is creating conflicts with each of these, with the federal implementation of a federal scheme. And so if you look at the Clean Air Act as a whole and its ability to operate as that kind of nationwide control mechanism, allowing every state to come up with their own, in fact, additional taxes on activities that are occurring in the energy field would interfere with that national scheme. And so I do think that we need to think about the Clean Air Act in terms of its holistic operation and the inability to continue to operate it in a clear and consistent manner across all the states. There was a very, unlike water, and I do think we need to be careful about bringing in the water precedents, because unlike water, which Congress itself provide a much greater role for state regulation in the water space, in part because there's much more intrastate activity and much more identification of intrastate activity that can be controlled in the Clean Water Act. And so you have the ability to have authorized plans under the Clean Water Act that the states, in fact, operate and implement in ways that don't have a direct corollary in the Clean Air Act. So the transboundary effect of air, I think, is far different than the transboundary effect of water, and so I would be careful about borrowing from some of those precedents that are coming from the Clean Water Act. The other concern here is whether or not every state will come up with different standards for what constitutes basically what becomes a liable discharge, and those different standards also will create operability problems that will interfere not just with the Clean Air Act, but also with the competing and balancing interests of energy production that exists inside the entire federal scheme, which Congress controls. And so our energy production priorities and policies will also be disrupted, and I think when you're looking at those things as a package, this is an area which is of national and international concern, which only Congress can in fact fix.
Yeah, I'd say they're preempted largely for what most people have read in some of the GHG tort case decisions. It's, the savings clause gives states a lot of leeway to regulate air emissions within their state. So Vermont can go to town with all the heavy industry inside of its borders. But it does preempt any regulation of out-of-state air emissions. And there are other mechanisms in the Clean Air Act to deal with out-of-state air emissions. It doesn't allow this type of scheme. And if you want to step even further afield, you're resorting to federal common law to regulate, emissions from outside of the country, which some of these seem to purport to do. You simply can't get past the strictures of both the Clean Air Act and really the inherent limits on state law. The fact is, everybody would laugh if Michigan said, we're going to impose our union laws on the state of Alabama. Be like, yeah, whatever, dude, go ahead. That's really sort of the flip side of the coin here. It's not just that the Clean Air Act preempts. It's that if Vermont wants to tell charge a company that runs a Houston refinery for, its GHG emissions or its production, go ahead. You don't have any real power outside of your borders. And that's really what it's all about.
Yeah, and I think borrowing the language from the opinions that have resolved this, both AEP as well as the opinion out of the Northern District of California, the Chevron case versus New York, those tort law cases are explain much of this preemption analysis and why it is necessary in terms of the state as a state being able to impose liability upon energy production. And I don't think that changes simply because you replace a state court or a state tort law with a state legislative act. It is simply the same effect, and that effect can carry over. And as you mentioned, Jim, one case that deals with this about if you want to do it about just what's inside your borders, perhaps that's a different category, but these things are not written in that way. The Delaware GHG case, that case did in fact describe and say, if you want to proceed here with a lawsuit that is only about effects in Delaware from activities in Delaware that caused harm to people in Delaware, then perhaps you can do that. But I suspect that case will never go anywhere because factually you just simply cannot do that with transboundary error. And so that's why there are some things which the states are not supposed to do, and there are some things that the states are just incapable of doing as a matter of science.
Any additional thoughts? All right, well, let's move on to the second question, or the second issue. Can climate superfund laws premise liability on emissions that originate outside of their respective borders? I know we've touched on this a little bit, but if there are any additional comments.
I'll just throw in, this is where I think the product's liability might be important here. Because these are styled as going after the producers and refiners of the products, they're really saying that these products are inherently dangerous. And we have products liability across state lines all the time. And that's why I think it's interesting that the states have framed these as it's the producers of products that are liable rather than the emitters of pollutants who are liable. So I do think that changes this analysis a bit. Unlike others, I don't think it really raises a dormant commerce clause issue because we're not discriminating against out-of-state products. But I do think it does matter that the climate superfund laws are not targeting the emissions per se, but the products.
So if I can just take us back to an understanding of why we established the union in the first place and why we have an interstate commerce clause. The Articles of Confederation were seen as principally failing because they did not support a market between the states, because they allowed for one state to in fact impose tariffs and other obligations on other states, that they allowed for extraterritorial reach and extraterritorial effect of one state against another. It really was a confederation and not a union. And so one of the principal defects of the Articles of Confederation was this ability for one state to impose commercial barriers to the operation of a market between the different states. As a result, one of the key features of the U.S. Constitution was the placement of the power over interstate commerce in Congress. That is, the ability to regulate, to make commerce regular, to control interstate commerce was meant to be a federal function. It was meant to be a federal function in large part not so that the federal government could, in fact, interfere with private business, but instead so that the federal government could prevent states from interfering with other states in this free flow of goods across borders. Let me, I want to quote one thing from Alexander Hamilton on this, from Federalist number 22, in which he clearly indicated that one of the concerns that they were trying to overcome in establishing the Constitution was the ability for states to, in fact, take action against states they disliked or disfavored, and the resulting chaos that would occur when other states would choose to retaliate against them. We're seeing the same thing between foreign nations right now, right? As we speak, I'm sure Canada is drafting their retaliatory measures against the United States and vice versa, and so that's the kind of thing which was not supposed to be allowed inside the Union. In number 22, Hamilton says, quote, "The interfering and unneighborly regulations of some states, contrary to the true spirit of the Union, have in different instances given just cause of umbrage and complaint to others. And it is not to be feared that examples of this nature, if not restrained by a national control, would be multiplied and extended till they become not less serious sources of animosity and discord than injurious impediments to the intercourse between the different parts of the Confederacy." And this idea that there would be animosity and discord, that we would not have a union and we would instead have warring states was a major concern. So when, at the very least, in the spirit of this, these things help to create a discord between the states that is against the spirit of the Commerce Clause and the movement away from the Articles of Confederation, if not indeed a constitutional violation itself. And so I do think we need to be concerned about the ability to impose this. I know the Dormant Commerce Clause is a difficult hurdle to overcome. Many of you know the National Pork Producers Council did, in fact, as Robin said, focus again on the discriminatory aspect of this. But let me offer two things on that as to why there might be some hope for revisiting that issue in these kinds of cases. The first is that in the personal jurisdiction case, Mallory versus Norfolk Southern, Justice Alito said if only you had brought a Dormant Commerce Clause case, this might have come out differently. But since it wasn't raised, we can't decide it. But this is the case where Pennsylvania said that simply certifying to do business in the state was enough to give Pennsylvania personal general jurisdiction over any company that registered in its state. And Alito said that that kind of ability to interfere with commerce may in fact be a Dormant Commerce Clause violation. And so it is not a dead doctrine in that sense. In addition, there are discriminatory practices here which include the favoring of green energy, essentially by taxing and making less competitive an alternative energy source or traditional energy sources. And so if any one state can favor in-state interests in terms of who they favor as businesses who are competitors with others by imposing a production tax on one and not the other, then I think that you do have some concerns, again, about this. It is a muddy area of doctrinal jurisprudence, but certainly one which we, at the very least, was intended to be controlled by the Constitution, and we would hope that I would hope that perhaps there's some room for the court to be considering it in this space. I'll say one last thing on that is I think if you consider this effect on controlling out-of-state activities as well as international activities in conjunction with the placement of Commerce Clause authority inside of Congress, and think about these things two together, I think it complements at least the preemption analysis, and it's important not only for an independent analysis of, say, Dormant Commerce Clause or other constitutional violations, but that analysis itself makes it even stronger a claim that when Congress has the authority to do this and has exercised that authority, that they have displaced the state's ability to do so or preempted the state's ability to do so.
I'm sorry, I forgot the question by now.
Can climate superfund laws premise liability on emissions that originate outside the respective borders of those states?
Oh, I think people have gotten I think I touched on that in my last response. I will say I was intrigued by something that Professor Craig noted. She said, well, this isn't all too different than your typical products liability case where you have products manufactured out of state. I'd say there's a pretty good reason that the GHG tort cases did involve a lot of products liability actions, whether it's failure to warn or design defects or manufacturing defects or claiming that gas and oil and coal are ultra hazardous and subject to strict liability. That's because even in the most plaintiff-friendly jurisdictions like New Jersey, you just wouldn't meet the elements of those tort cases. To back that into a legislative decree that oil, gas, and coal are ultra hazardous, and yet now they're going to pay money, but they're not going to be banned, and the state's going to continue buying them at astronomical rates. I just don't think they'd go over very well, even if it doesn't touch on like hardcore preemption issues. I don't think that would work very well. There's a reason they didn't do it that way.
Thank you. Any other comments? All right, well, let's move to the third issue raised by climate superfund laws. Are these laws unconstitutionally retroactive?
You want me to start again?
Whoever would like to jump in is welcome to.
I actually think this is one of the places where these laws are vulnerable. Again, though, I will stress that they are set up as toxic torts legislation, not as emissions legislation. And this is a classic toxic torts problem for products liability. The classic case and the mechanism I mentioned earlier that these laws are kind of incorporating was for DES. So DES was a drug given to pregnant women. Didn't hurt the pregnant women at all, didn't really hurt the fetuses until they hit sexual maturity. So you've got DES daughters and now even DES granddaughters who are harmed by that product. This is liability arising way after the drugs were manufactured. These kinds of toxic torts are difficult under all sorts of circumstances, and various states have developed mechanisms to deal with them. One of which in the DES context was market share liability, and that's what a lot of these statutes, climate change superfund statutes, have incorporated, is we're going to charge you your market share of what you did or what you contributed to the problem, focused on those products. Getting to the point of does this account for everything? No, it doesn't account for everything. But according to the EPA, in 2022, burning fossil fuels accounted for 74% of total GHG emissions. So we do have a large share of the market, the people generating the products that generate the problem, involved in this litigation. So, like I said, I do think this is one of the places where these statutes are potentially vulnerable. But there are analogies that could lead some courts to uphold them. I will also note that the Supreme Court has left us with a little bit of a fuzzy note on how to analyze these cases from Eastern Enterprises, whether you view them as takings or whether you view them as due process violations.
Yeah, I think that there is a vulnerability here, and it is on multiple levels. So I think we can probably see if there's a follow-up question you want to have here. But there is the concern, first and foremost, about due process, and that is, should someone be able to be held liable or told they have to pay some kind of, essentially a fine, for activity that was entirely lawful, that they did not have an opportunity to avoid the liability in the first place. When we're talking about other activities that perhaps there is some determination later that the person would have known that their activity was unlawful and was a wrong, here we're just redefining what is and is not a lawful or wrongful activity by legislative fiat. And that is not typically what we would uphold under due process, where there's due process of law, rule of law values, in which people need to know what, in fact, are the standards by which liability will attach before they act. And if you want to do something prospectively, that's quite different. But that's not what this legislation is doing. And in fact, as Jared read at the very beginning, this is meant to be backward-looking. And some of these are going back to 1995. I think there's some states looking back to 1965. But there's a lot lot of attempt to control past behavior that no one would have known to be wrong at the time. That's quite different than some toxic torts and other things in which you are committing something which was within the general standards of being a wrong, in which there's also proof of causation, there's proof of there's traceability, and there's allocability. And all of those things are difficult to do in this space too, for all the reasons that Jim mentioned before. You can't allocate this to these individuals. Again, it's just sort of an arbitrary determination of allocation to a certain sector and only certain members of the sector. And it's not even the people who are actually doing the polluting, but instead the people who are creating the products that are then used by others to pollute. So when you look at the cases that are in this space about whether or not something which is retroactive does in fact cross the line in unconstitutionality, they're looking at whether or not it is arbitrary, whether or not it is in some way otherwise irrational. And I think that you can meet those standards here when you're simply picking out a few people and saying you are responsible for this as a result. On the takings analysis in Eastern Enterprises, either way that you look at Eastern Enterprises, whether it's a taking issue or a due process issue, that is a situation in which there was an imposition of vast liability for health benefits from 30 to 50 years prior, which could not have been contemplated on the part of the companies who are subject to the act that was attempting to control this. And that is, seems precisely the kind of situation in which you are now saying something which occurred many, many years ago, which was not considered then a wrong, can now be deemed a wrong. Lastly, I'll just say, we should, to my opening remarks, we should be considering whether or not the legislature is supposed to be able to do something that the judiciary could not. And I think the answer is no. The Due Process Clause applies not just to acts by the judges and how they apply rights inside the courtroom, but it applies to what the legislature is capable of doing. They're not capable of doing something simply because you couldn't meet the hurdles to do it in court. And I think that should be how we judge this. Last thing I'll say, and I think we get to this in one of the later questions, is the U.S. Supreme Court recently also, on that same line of reasoning, that the legislature is governed as much as the courts are by the Constitution. The Supreme Court recently decided a case called Sheets, which it found that the legislature is capable of creating an exaction which is unconstitutional, that is requiring a landowner to do something before, including make a payment before getting a permit. And we had long known that if a judicial decision could not uphold could not impose an exaction, the legislature can't do it either. And what I think we can really think of these things as are an exaction to do business. In order to do business, you are being required to pay this. It's just a retroactive exaction. So if you combine our retroactivity analysis with the recent case on takings and legislative exactions, I think that there's an opportunity for the court to kind of think about how those things go together.
I will say that CERCLA challenges there were retroactivity challenges to that, and they lost. It's worth noting that a lot of them pointed out that CERCLA is a cost recovery and reimbursement scheme, and there's remedial work to be done. That's not so in these cases, so maybe the old CERCLA retroactive liability cases aren't exactly on all fours. I will say that once you get out of criminal law, retroactivity becomes very tough. I will also say that if there's a case for making it easier to show illegal retroactive liability in a civil setting, this could be it. You don't have to look far down the road to stop at oil, gas, and coal companies. They're going to be looking to vehicle manufacturers and airlines and package delivery companies, electricity producers, home builders, and pretty much any industry with a couple of nickels rattling around their bank account. They'll be next. And the fact is, red state legislators, they get awfully creative too. I mean, this is upheld, then why not go after social media companies to fund teenage mental health programs or food companies for obesity programs? You can get creative and go after anybody for doing a lawful thing and then saying, well, that caused some type of social ill, now we want money from you. So that could play a role in any type of retroactivity analysis. You're opening a pretty big door here that you probably don't want to open.
Anything else? All right, well, let's move on to whether climate funds are analogous to CERCLA liability. I know Mr. Wedeking has already made some comments on this, but if anyone else has additional thoughts.
I'll throw in, I agree with Mr. Wedeking that it really isn't analogous to CERCLA liability at all. But as I noted at the beginning, I do think these statutes share some commonalities with the Superfund tax, which prior to expiration in 1995 included excise taxes on crude oil and imported petroleum products, an excise tax on 42 different chemical feedstocks, and a special environmental tax on corporate income. So it was a recognition that even though you're not the actual polluters of every site, we're going to have some orphan sites, and your products contributed to that common problem. I think some of these statutes have the same spirit of it might not be you doing all of the admissions, but your products are contributing to a common problem. Not exact analogy, but like I said, I think it's got some of the spirit of the Superfund tax in them.
I'll defer mostly to Jim's comments on this, but I'll add two things. One is it's important to recognize that CERCLA was indeed a national scheme. And you do not have 50, you do have some state sort of cleanup systems, but the idea of CERCLA did not allow for the imposition of double liability. We're going to talk about double liability coming out of paying in tort suits as well as paying in legislatures. But there's also, because you can't actually identify the source of these activities, and we talked already about sort of it's an interstate transboundary issue in which allocability to any particular site is difficult, you are almost by necessity going to have Vermont and New York imposing costs on a producer for the same activity, right? It is, whereas that can't happen in a nationwide CERCLA system. But instead here, you will have, because they can't actually say we're going to apply for exactly what you've only done inside of New York, it is instead what this energy company or refiner or producer has done in multiple states. And so the idea of double payments just from different state Superfund laws is a real problem there. And Jim has touched on the second point, but I'll just underscore that Superfund also, CERCLA, also has protections against and ensuring that potentially responsible parties are in fact eventually going to pay, provided that they're not otherwise judgment proof, which has always become a problem in CERCLA. But the PRPs get to pay. There's no contribution action in these laws in which everyone in this room can be sued by the energy producer who has to pay and say, okay, each of us should pay our fair share. And so when you're thinking about retroactivity, when you're thinking about the out-of-state impact, when you're thinking about any of those things in relation to CERCLA, there are tempering influences inside the carefully crafted CERCLA regime which protect against some of the dangers of these effects. And so when you have, say, retroactivity, which has to be based on irrationality or arbitrariness, there's a more credible claim that CERCLA is not arbitrary or irrational in the way that it's structured and the protections it provides for innocent or parties, or even the proper allocation within parties, and not an excessive application of liability to one.
Only to touch briefly on Professor Gregg's point, I think from a due process perspective, there's a very big difference between a tax on an industry to fund a public service versus a decree of liability against an industry, not least of which is that a state can only tax what goes on within its own borders. So it'd be very different if this was deemed to be a tax. We probably wouldn't be here because it wouldn't be worth talking about.
Anything else? All right, then our final issue, is there a potential for double liability from ongoing greenhouse gas tort litigation and climate superfund laws, and does that raise separate or additional legal concerns?
I'll start only to note that CERCLA has an express statutory bar against double recovery. You do have a situation where a the EPA could clean up a site and the state could say, oh, we're going to go clean it up too and clean it up different or something like that. So EPA does have a statutory bar on that. Those types of bars are absent from all of the bills and laws that I've seen.
But I would also add that the greenhouse gas tort litigation is not necessarily seeking the same remedy. So it's kind of a tort. If you do one thing that causes multiple harms to multiple people, it's not double recovery to have to pay those multiple harms. So it kind of depends on what the tort litigation is seeking. And again, what these state statutes are looking to develop is a climate change adaptation fund to fund either state projects or to give grants to people to engage in projects to adapt to climate change. That doesn't necessarily create a double recovery problem if the adaptation fund is in fact limited to what the state actually needs to spend to adapt to climate change, so you're not overlapping with other states. And if the other lawsuits are seeking different kinds of problems, like damages to private property or personal injury in the case of flooding, for example. So it would depend on how the lawsuits lined up with what these statutes were trying to accomplish.
I suppose there might be a situation in which you could say that there's completely distinct, but I think there's way too much overlap in terms of what is being sought in these lawsuits and what's being sought here. And there's the possibility of, I mean, even if people are asking for two different things and one person says, I would like this prize and I would like this prize, and so you have to give someone two prizes. I mean, does the wrong warrant giving two prizes to these individuals, right? The wrong may have only warranted a payment of $50,000, not a payment of $100,000. So in that sense, there is the possibility of giving more than you should owe in these situations, even if we could admit culpability that something is owed in the first place. So I think that is an unavoidable problem, and it's unavoidable in part because there's no coordination opportunities. There is no coordination opportunity where the legislature can sit down with the court and say, okay, I mean, there's separation of powers problems with that, first off, right? The legislature can't sit down with the court and say, you can't order this remedy because we already gave them that remedy over here, and the legislature can't really decide that, oh, the court's awarded it here, and so we're not going to award it there. So this is another reason why, and that coordination aspect is part of the reason why courts have said this is a political issue in which, if we think about the comparative institutional competencies of the different branches of government, it belongs in the political branches. And when it belongs in the political branches, then we have to ask the horizontal federalism question: does it belong in the political branches at the national level, or does it belong in the political branches at the state level? And I think that question too has been answered for things like this. It belongs at the national level because that's the only place, the political national level, where that kind of coordination can occur. So I think without that, it's inevitable that you're going to have conflicts between these different remedies.
Any additional comments on this question or anything else, including New York football teams?
I want to get to the audience questions, but I will say one other thing. I don't know how much of this is at play, but on the double recovery issue, I do know that many states are displeased by the municipalities moving forward, and the fact that they haven't been able to keep the municipalities from not moving forward in some of these states, where these are states who believe that it is our power, duty, and authority to decide whether or not to sue on behalf of the state or on behalf of the state citizens, and the municipalities should not have the authority to go after this. Some of them are jealous about the money going to the municipalities, and so this is a way in which a state legislature can get money that they're not without suing. So I think that the idea that the states are somehow going to be able to coordinate with the municipalities is also already belied by the evidence that shows that many of these states are frustrated with the municipalities going rogue and asserting authority to bring these tort suits.
Thank you. All right, well, if there's nothing further, let's pause for a moment and thank the panelists for their participation this afternoon. For anyone that would like to now ask questions of the panelists, we have a microphone that's conveniently placed, I believe. I see it in the back of the room. Please, if you have any questions, state your name and affiliation as appropriate, followed by a concise question, preferably that ends in a question mark.
Thank you. Good afternoon. My name is Nick Iacono. I'm an associate at Tort and Law. Question about preemption. In addition to the arguments that these state Superfund laws are currently constitutionally precluded or federally preempted by federal law like the Clean Air Act, is there an argument to potentially be made that they're also potentially preempted by federal EPA regulations? EPA regulations regulating greenhouse gas emissions and air quality standards. And if not, do you think EPA could strengthen the case for preemption by passing a regulation through rulemaking? And if so, what would that rule look like? So I think there may be probably three parts to that question, but if you have any thoughts on that, I'd be grateful to hear them. Thank you.
Yeah, you know what, let me take a first hack at that. I've been dealing with this to some degree with some people, especially with news about potentially reconsidering the endangerment fine. I think I may be in the minority here, but as I read things, including the AEP cases and related ones, preemption comes from EPA's authority to regulate, not how it chooses to regulate or even if it chooses not to regulate at all. So I think it's already there as a product of the Clean Air Act, and it really doesn't matter what EPA does or does not do, there will still be preemption.
I agree with that.
Oh, I'm not crazy then.
I agree that EPA has the authority to preempt whether it regulates or not. The court was clear about that, but I still say that, we have that presumption against preemption, and this is not interfering with the regulation of emissions.
All right, thank you. Any additional questions? Well, I'm going to take that as a sign the panelists were very thorough in their presentation up to this point. With that, I think that the Federal Society has a few comments, and we'll thank everyone for coming.
Thanks, everybody. Thank you. Thank you.
Thank you.
Well, thanks to our panel for an insightful and informative discussion. We look forward to having you all again soon. Thank you as well to the RTP team for helping to set up today's event. And to all of you, thank you for coming. We look forward to seeing you again. We are adjourned.
Thank you, sir.